Welcome to the 10th lecture of Ethical Issues for Modern Computer Professionals. Thank you for submitting the assignments I had given in the last class. Many important points have been identified by you, which will help me to proceed with today's discussion. Uh, Let us start by revisiting the background of this Personal Data Protection Bill 2020. As I had mentioned in the last class also, it all starts with famous Aadhaar litigations, with tremendous push from the government for making Aadhaar linking mandatory for social welfare schemes, bank account, mobile phones, everywhere almost. Experts and activists were raising their concern about possible privacy breach. A number of petitions were filed before Honorable Supreme Court of India to adjudicate whether citizens of India have a fundamental right to privacy or not, and how much these other linking are uh, going against that particular right. So, Honorable Supreme Court, in its landmark decision on August 2017, had declared that right to privacy is an intrinsic part of right to life and personal liberty under Article 21 of the Constitution. And this decision forces the government to change their trivial stand on privacy, where they were trying to portray this right to privacy to be a concern for elites only. Uh, and so they need to seriously rethink about their policies, and central government was also forced to consider this protection of personal data of citizen in the age of these modern technology based systems. And accordingly, government of India appointed a 10-member committee of experts headed by Justice B.N. Sri Krishna to identify key data protection issues and recommend methods. That was done in July 31, 2017. Um, the committee submits their report, a draft data protection bill, on July 27, 2018 to the concerned ministry. And the ministry, after some kind of revision, they placed it in the last year for cabinet approval. And after getting the cabinet approval, the draft bill have been placed to the parliament. And currently it is under the review of a joint parliamentary committee. So the proposed law is applicable to all the organizations, irrespective of public and private, dealing with personal data of Indian citizens, irrespective of their location also. It is not only limited to Indian company. The foreign company working with data of or dealing with data of Indian citizens will also come under this personal data protection law, when it will be established as a law. Just like GDPR is applicable to all the organization dealing with personal data of citizens of European Union and territories. Now, like GDPR, PDP, or this personal data protection bill, also defines personal data to be the piece of information that uniquely identify an individual. And in similar line, it also restricts processing of personal data by any data fiduciary except for any specific, clear, and lawful purpose. Now, in order to prevent discriminatory use of personal data, PDP also identifies a subset of personal data as sensitive and asks for special care in handling such data. PDP also mentions about the composition of a notice similar to terms of service, uh, to proactively advertise some key points at the time of collection of personal data in any form. This includes purposes for which the personal data is to be collected and processed, nature and categories of personal data being collected, right of the data principal to withdraw his or her consent, and the procedure of such withdrawal, the consequences of the failure to provide personal data, and also the entities or individuals, like other data fiduciaries or data processor with whom the collected data may be shared. Um, Now, in order to protect data principles for any kind of financial or social loss, maybe incurred by inaccurate, incomplete, and misleading outcome generated by some poor processing or casual processing of data, PDP also uh, puts stress on quality of processing of data, and it is expected to tackle the scenarios like denial of loan for an individual based on inaccurate credit scoring or something like that. So this is very important and interesting point that has been mentioned in PDP. PDP also puts a limit on the retention of personal data. And according to this proposal, the data fiduciary shall not retain any personal data beyond the period necessary to satisfy the purpose for which it is processed, and it should delete after the work processing is done. And in case it is required to keep the data, retain the data for a longer period of time, data fiduciary recommended to undertake periodic review to determine whether it is at all necessary to retain the personal data. Otherwise, it should delete it. Like GDPR, PDP also advocates the need of informed consent to be obtained before processing of personal data. And it also proposes that the consent for processing any sensitive personal data should be obtained explicitly after informing the purpose and possible consequences to the stakeholders. Now, um, so far, I mean, it is clear through the discussions we have. As expected, this personal data protection bill proposes various mechanisms to protect users' personal data in the present age of modern, sophisticated data-driven technologies. In fact, if you see that it has dedicated an entire chapter to demonstrate the rights of data principal or data subjects or user, whatever you may call user, including right to correction and erasure and right to be forgotten, many things. I mean, these concepts we have come across already in our earlier discussions. And if you are interested, you can go through this chapter very carefully to understand. Because as I have mentioned, you have to understand um, as a normal citizens what is the right. At the same time, you should also keep in mind that you need to uh, enable your develop technology to comply with that. So your responsibility is twofold. You have to understand from a citizen's point of view and also help other fellow citizens to understand their right, and also from a developer's point of view, working for data fiduciaries, you need to ensure that your product or services are complying with this type of thing. Um, However, I mean, so far this is kind of very common to any privacy regulations like GDPR, similar thing we have seen. But um, uh, as some of you have already pointed out, there are few exemptions on the restrictions of accessing and processing of personal data that are laid down in this proposed bill, are opening up its darker side, maybe. For example, it allows processing of personal data without consent. I mean, if such processing is necessary for some so-called reasonable purpose, and which reasonable purpose, I mean, this term is very vague, but the bill has mentioned some of possible purposes like prevention and detection of any unlawful activity, including fraud, whistleblowing, mergers and acquisitions, network and information security, credit scoring, recovery of debt, processing of publicly available personal data, the operation of search engine. And more menacingly, personal data protection bill tries to offer special exemptions for central government agencies. I mean, it is observed that it grants access to personal data to the central government without appropriate safeguards, like any judicial oversight or any other kind of safeguards. Um, in fact, government can ask any data fiduciary to provide user personal data under their possessions. Although it has mentioned um, anonymity, I mean that the uh, data fiduciary should hand over the data to the government, personal data, after anonymizing it. But it is not clear that what would happen if a data fiduciary provides the data to government agencies without properly anonymizing, because intentionally or unintentionally, because we have seen anonymization is very, very difficult. In many cases, if trivial methods of just de-identification is used for anonymity, obtaining anonymity, then it may be very easy to re-identify. I mean, so this is very serious issues we need to consider. Actually, access to personal data of citizens by government without appropriate safeguards, I mean, it may lead to undesirable state surveillance. I mean, forcing the citizens to give up all control over their personal data in the name of welfare, security, protection, rule of law is analogically similar to, I mean, portray the government as like ultra possessive guardian of Indian citizens. I'm not saying that such access should not be there at all, but it should be done only in some very, very extreme cases, and obviously under the mm, judicial supervision. Okay. So the exemptions in its current form have dangerous potential to act as tools to trivialize the notion of right to privacy by justifying surveillance and thereby demeaning the democratic rights of citizens. And this issue become more worrying, I mean, when the head of the expert committee, Justice B.N. Krishna, that committee preparing the initial draft of the bill, raises his concern on the alleged modification of the draft by the ministry. I mean, by removing the judicial oversight in case of government access to users' personal data. Uh, Moreover, the composition of the proposed composition of DPA, the Data Protection Authority, I mean, which is supposed to be the supreme authority to resolve any dispute that may occur, is also very absurd. I mean, it is completely dependent on the central government. I mean, all the members are either from central government organizations or being nominated by central government. So, for obvious reasons, since central government being a stakeholder, I mean, it may lead to conflict of interest in case of resolving dispute. So, before conclude, I would say that in a nutshell, uh, these issues demand serious discussion in all domains, in expert, normal public domain, government, everywhere, as the proposed law has the potential to act as a two-sided sword. I mean, on the one hand, it is protecting our data, citizens' data, um, protecting personal data from, uh, I mean, uh, protecting our data from abuse or misuse. But at the same time, these exemptions extended to central government, it is also very may lead to undesirable consequences. So, importantly, since I mean it has not yet established as law, it is under revision by Joint Parliamentary Committee, who is currently reviewing the bill, and they are also seeking feedback from stakeholders. So I would request you to kindly put your sincere effort, because you are a little bit better position than an layman um, user with your background knowledge. So you should put your sincere effort to just look into this bill again and again without getting biased, to understand the issues and their impact, and extend your constructive suggestion to the committee. I mean, so that we can actually make the first data protection law of the country as best as possible. Thank you.